Hi, so this is Steve Carlson again. I'm recording another video about continuing on the proposed conclusions of law in a court battle in Ramsey County, Minnesota about the SAGE program, about the Breast and Cervical Cancer Prevention and Treatment Act passed by Congress, and why they're throwing Granny off the cliff. They're taking people out of their active cancer treatment. That is not intended by Congress, and they're taking away their treatment. They're taking away their funds to fund their treatment while they're actually in actual cancer treatment. And so I made a video called it's called "Fight Like a Girl, Can't You Feel the Rage?" And it's about just this case and about many, many cases like this. Hundreds of women in Minnesota are already being treated like this by the respondent, Commissioner Emily J. Piper, and also the Minnesota Health Department and Governor Mark Dayton. And this is just wrong, and I'm explaining why. So it's going to get less exciting now, but I'm going to read from this proposed findings of fact conclusions of law. These are conclusions of law number 15. The court finds, while preserving, and excuse me please, but the court finds while preserving the fiscal integrity of welfare programs is a legitimate state interest. This is not a compelling reason for the county's wrongful action, repeatedly terminating and depriving recipient of her treatment payments as they did, and this stretches all the way back to 2014. Now this begins with Goldberg versus Kelly, the famous U.S. Supreme Court case. While the commissioner argues Medicaid is a program of limited funds that cannot provide meaningful benefits to everyone. This, we're talking about expanding Medicaid. This is what they're talking about, expanding. They're citing a 1982 case from the U.S. Supreme Court called Schweiker versus Holder. And the commissioner argues that preserving the fiscal integrity of welfare programs is a legitimate state interest. And so limiting the MABC program eligibility to individuals with breast cancer who are too young to receive Medicare and not otherwise covered under credible coverage serves that legitimate purpose. And but this the court finds this grossly misapprehends the sincerity of the Congress, many of whom had breast cancer and simply couldn't imagine the plight of those too young or too poor or uninsured to get treatment. Now, Medicare does not provide this cancer treatment. All right, they pay 80% of some things, and so women who can't get this program, I've talked to the people at the hospital, and when these women come in over 65 and they can't get chemotherapy, they need to rush to a foundation. They might be able to start some treatment, but if there isn't charity there, these women are not going to get treatment. And cancer doesn't care. I don't know if you know much about cancer, but it's not the kind of thing that cares if you don't really want to treat it. It does its thing. And this is what Congress was trying to stop. All right. So many of those, when they created the program, they already had breast cancer, members of Congress. And they were very, very serious about taking care of this. Now, so certainly these members of Congress, the court says, never intended anything less than meaningful benefits to everyone actually accepted into the program. Those people were accepted in. Further, fiscal and administrative burdens are specifically found to be outweighed in Goldberg by a corresponding compelling state interest, which the Supreme Court in the 14th Amendment had in ensuring even the possibility of erroneously determining an eligible recipient as ineligible and withholding those life-saving benefits, interrupting them, which in this case they've done for more than a year, would be eliminated. The court also requires a moratorium on reclassifying recipient or any other woman in the MABC program as ineligible because they aged to 65 or obtained Medicare while in their BCCPTA cancer treatment. Such moratorium to remain until such time as the Commissioner presents to this court an impact study, determining the impact of this practice on changing women's programs on the efficiency, economy, and quality of care, all consistent with other Medicaid policy requirements. The 8th Circuit, and we're in the 8th Circuit here. The 8th Circuit, talking about the U.S. Federal Court of Appeals. In Pediatric Specialty Care versus Arkansas Department of Human Services from 2004, recognizes that these categorical Medicaid benefits contain a safeguard of the security interests that the recipient has in already acquired specific benefits. Here, payment for breast cancer treatment. The Congress, but also the legislature and the Commissioner of Minnesota and Minnesota Health Department as well have announced the rights that eligible women, that is to say those determined or already determined to be eligible, have in MABC and BCCPTA. And that is, those rights are to have their treatment paid for through a Medicaid program. And the court said, quote, over 10 years ago, our court held that 1396A-30A, that's the equal access provisions that require consideration of the efficiency of doing something like this, throwing women off, the economy in terms of their medical treatment of throwing them off, can they pay for it, and the quality of care, that these created enforceable rights, says the 8th Circuit. Enforceable rights for Medicaid recipients and providers. We find it entirely appropriate for the plaintiffs to base their procedural due process claim on their clearly established right to have equal access to quality medical care as defined by 1396.330A. That again is the equal access provision. Specifically, our court now would say, the 8th Circuit found the Commissioner must employ, quote, methods and procedures relating to the utilization of and the payment for care and services, unquote, as necessary to, quote, assure that payments are consistent with efficiency, economy, and quality of care and are sufficient to enlist enough providers so that care and services are available to the general population in the geographic area. And so that's other services that are offered in addition to this cancer care. And that was unacceptable in Arkansas, even though these children were not going to receive Medicare, which itself, that's a change in the level and method of payment for some services. When you change from the Medicaid program for breast cancer patients and you put them in Medicare, that is a program change. And the law of Medicaid and the 8th Circuit, and they say it is protected by equal protection and due process, that it says that you can't make that program change unless you first have an impact study in which you consider the efficiency, economy, and quality impact of what you're doing. Now, the court further finds that any questions such as Mr. Westmoreland's, that's Timothy Westmoreland, at that time was the head of the CMS, then head of CMS, and the interpretation of the words eligible, what does that mean? Age 65, what does that mean? Or treatment, are clearly answered by this equal access provision and by the findings of the 8th Circuit and the Supreme Court, because that cites a lot of Supreme Court decisions requiring 14th Amendment protections against a bad, reckless interpretation that allows substantive rights to be violated by eliminating the procedural due process requirements, as the Commissioner has done by not doing this impact study considering this program change. Now, the 8th Circuit went further than the Commissioner does in citing Goldberg, among other important U.S. Supreme Court precedents. Quote, it is well established that the 14th Amendment's procedural protection of property is a safeguard of the security interests that a person has in already acquired in specific benefits. That's from Board of Regents versus Roth from 1972. Property interests, of course, are not created by the Constitution. Rather, they are created and their dimensions are defined by existing rules or understandings that stem from an independent source such as state law rules or understandings that secure certain benefits and that support claims of entitlement to those benefits. And once you've acquired those, you can't just throw them away or throw people off. And in this case, those state rules would include the Minnesota MABC and SAGE statutes, but also the federal rules and statutes, which include the Breast and Cervical Cancer Prevention and Treatment Act. And this, by the way, is a follow-on and the completion of the National Breast and Cervical Cancer Early Detection Program, which was started in 1990, which screened women and didn't treat them, and just watched them die in many, many cases. And which, again, well, they fixed that in 2000, and now they're trying to undo that fix. That's because of money. So when it's said that they acquire certain rights that can't be taken away in this, then they say that that is agreed to by Goldberg versus Kelly, which is the one that the state of Minnesota purports to follow, the so-called fair hearing before they can take away welfare entitlements, which I don't think this is a welfare entitlement, and I'll explain why. But they said you can't do that without a fair hearing, where you have notice, adequate notice, and also an opportunity to respond. Very often they don't use that in the commissioner's language, but that's what Goldberg requires. And maybe they'll have a PowerPoint presentation for some lawyers or something, which will tell them about the whole Goldberg requirement. But Minnesota admits that you can't do this, and Goldberg says that it recognizes that federal and state regulatory frameworks, like the commissioners, have created constitutional property interests in continued receipt of welfare benefits. You can't take those away without a hearing. Okay? Now, over 10 years ago, our court held that 1396A30A created enforceable rights for Medicaid recipients and providers. We find it entirely appropriate for the plaintiffs to base their procedural due process claim on their clearly established right to have equal access to quality medical care. And that requires the state Medicaid plans employ methods and procedures relating to the utilization of and the payment for care and services as necessary to assure that payments are consistent with efficiency, economy, and quality of care and are sufficient to enlist enough providers, doctors, so that care and services are available under the plan, at least to the extent that such care and services are available to the general population in the geographic areas. You don't want to discriminate, this plan says, between the general population and what Medicaid recipients get. This is people from the breast cancer program or just the general Medicaid. That's in the Medicaid Act that they're citing. By the way, that's what this is, the Medicaid Act. So the district court in the Arkansas case, the pediatric specialty case, found that termination of parts of the CHMS program, that's Children's Health, would result in a change in the level and method of payments for some services. We agree. In fact, it is difficult to discern how a decision to eliminate components of the CHMS program but continue to pay for CHMS-like services is anything but a change in the methods and programs for payment of such services. And that certainly applies here. How can that not be a change, throwing the women off of their treatment program that's not replaced? Now, since this case, the case in Arkansas, involves a prospective due process violation, we look to whether the injunction adequately addresses what would otherwise be a denial of the plaintiff's constitutional rights. The district court, and by the way the state of Minnesota has set this up, you can't even talk about a constitutional issue. You can't entertain constitutional claims until you get to this district court judicial review level where we are. So all throughout the administrative appeals process of Commissioner Piper, you cannot talk about the Constitution. They may politely listen to you, and then they'll say, we are not given authority to determine any constitutional claims, and therefore, unfortunately, we can't talk about it. So no matter the fact that you showed that this violates doesn't matter because legislature told us we can't talk about it. Unbelievable. So this is the right level to talk about an injunction on the basis of these constitutional claims because you can't talk about them before. So the district court also held that before, this is in Arkansas, the defendants can terminate Medicaid payment for services. They must conduct a proper study, they're talking about the CHMS services, and assure the citizens of Arkansas that the factors of economy, efficiency, quality of care, and equal access will not be jeopardized. And this is what I'm asking the court to say that this state must do, because they obviously are jeopardizing these people, the citizens of Minnesota. Such an order permits the procedural due process issue to be revisited following completion of the study, while remaining true to the Medicaid Act's equal access provision. We find no error in the injunction as so limited. So that's their case. So respondents further argue that Minnesota statutes are presumed to be constitutional. State versus Fritsch, just in 2016, the Minnesota Supreme Court. But this simply means that the statutes should be construed to be constitutional, and if any part is determined unconstitutional, the remaining portions will be construed in a way that is or could be constitutional. And Judge Buster and also the appellants have shown a very constitutional way it could be construed. But Minnesota courts cannot create a presumption of all acts of the legislature as against any federal constitutional or, for that matter, state constitutional challenge. There is no doubt that the 14th Amendment requirement of equal protection cannot be set aside by any presumption that no Minnesota statute can be examined for equal protection violations. The court further finds the commissioner did not fulfill due process required in the 8th Circuit and beyond under the Medicaid so-called equal access provisions. The actions here of the commissioner and the county respondents also shock the conscience and interfere with rights implicit in the concept of order and liberty. This is because the government must be restrained from this kind of reckless action which takes a federal program and essentially voids and dismantles in the interest of preserving fiscal integrity. Now, the court further finds that the privacy provision of the Minnesota Constitution is violated, where the medical provider is barred from making the best medical decision, for instance, choosing hormone therapy, and forced to use chemotherapy in order to provide a complete yet substandard regimen of treatment. It may be substandard to do the chemotherapy and no hormone therapy. The Minnesota Supreme Court has recently found this privacy provision in our Minnesota Constitution requires payment for abortion by Medicaid and transgender operations by Medicaid. And these cancer treatments are legal and also must be, like abortion or transgender alteration, allowed to be paid in total by Medicaid as a matter of privacy under the Minnesota Constitution. The violation of all these constitutional provisions of the federal Constitution support a 42 U.S.C. 1983 violation. That provision is intended to enforce these rights and entitlements federally protected against reckless disregard as exists here by state actors, including the respondents from the county and the state, and including the county itself, which is a person liable under that provision. These are important civil rights protected against injurious state action. Now, the rest of these conclusions of law, proposed conclusions of law, which I won't read here, talk about remanding this case back to the commissioner with instructions, including requiring procedural due process and avoiding substantive due process violations such as shocking the conscience and try to have some semblance of ordered liberty in the state of Minnesota before you throw Granny off of the cliff. I'm Steve Carlson again, and this is one in a series videos to educate you and inform you about what is going on with SAGE, with the medical assistance for breast and cervical cancer. These are very important programs. If these programs work, and I've run for Congress, and actually right now I'm running for Congress, and I have said this is a type of model, if we follow the law, which we have to have for the state's role to identify killer diseases, to identify health disparities where people are not getting the access that they need in order to survive these things. And I said this in 2010. My family was not affected by this until 2013. I had no idea this would ever touch my family. But because I was familiar with it, and you should be familiar with it, when it came in the mail, we had lost our Minnesota care. We paid our premiums, and the state legislature decided, hey, you don't need Minnesota care, so we lost it. And we were able to get her screened and the treatment paid for under this wonderful, gracious act of Congress. And we want you to get that too, if and when you need it. And in order to have those programs, or to even follow this strategy, we need to have honest government and judicial enforcement. That's what this asks for. And I'm just going to take this out with my rap video, which is called Fight Like a Girl, Can't You Feel the Rage? And this is a breast cancer awareness program.
My message to you is it's time for you to fight like a girl.
I don't know if you can hear that, so there you go.
Fight for the right to get on the same page. Breast cancer broken and it's so insane. These growing forms gotta fight your way. Gotta earn our faith on the goddamn day. Still dozens of women fit to enrage. It goes under the serious, it makes me furious. The commissioner's furious, court's not even curious, and they're throwing brains off of the cliff. The government doesn't even see the depth of grip. It's a broken for life, got a panel in death. You have to make a move just to get the life, so we got to fight. So someone else from Minnesota needs to me. Well, it's a state of the sweet land of liberty. Well, we put our rights and privileges all down in writing. We got the right to recite it. So we pass a lot to say that women from a disease. Rather than having what their money just to do as they please. They should be using all the effort to fight breast cancer. Instead they see the chance to play the necromancer. What Minnesota means to me is really chilling. Shouldn't say the right still is doing its killing. Sweet land of liberty, that's what it means. We are ready for fun. Gonna get excited. Don't want to make trouble, but you know even that. Top just a critical, I'll take you to test. Telling me they need Florida shot. They say she's signing up for a new kind of war. Warring women. I know the women stricken with cancer. They say she doesn't need the one to give them a chance to get war. She's 65 alive. She just will let us survive. Can't take the feeling with down in my soul. It came under the sun in the Super Bowl. Not just football, a nation state, American school, a constitution, and a people rule. Granted by God who gave us the tool to make the best laws, not to help our cause. So let's dance, let's move the nation ahead. Let's build the nation that the founders said. Sweet land, the liberty where the angels sing. Wake up, Minnesota, got the freedom ring. So let's pump like a girl all around the world. White girl, black girl, red girl, brown girl, Medicaid, black cells, going around. If you can't fight that, it's time to get down, girl. If you're 65 and you're still alive, well, you know that's the plan you were meant to survive. Trust may be prolific, a mind to be quiet. You got to push back, the mind to drive. Drive them out of office on election day. Don't let them stay. We're not here to play. They won't get serious. We're going to get serious. No, we don't fight in the fort, we don't fight in the cage, then a fight in the court for the battle of the age. Put the heaven to abort and you don't raise faith. Those who are poor don't make the grave. Hey, Attorney General, you might have to go federal, but to give you any static, make it automatic, take a woman's life, that's 65, the purpose of the program is to help us survive. Just like you think it came from a little boy. You're playing with a woman's life, you think it's a toy, you think it's a game, but you're out to destroy it. Fight like a girl, that's a wisdom book. And give it a whirl, and you fight like a girl. Fight like a girl in this one, girls.